Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. On October 30th, 2015, the EEOC published a proposed regulation that amends the regulations of the Genetic Information Nondiscrimination Act of 2008, GINA, as it relates to employer wellness plans. The proposed rule addresses the extent to which employers are allowed to offer employees inducements for spouses to provide their health information as part of a health risk assessment in a wellness plan. Generally, GINA prohibits the use of genetic information in employment and restricts employers and other entities covered by GINA from requesting, requiring, or purchasing genetic information, which includes genetic information of family members. Because the definition of genetic information is so broad under GINA, the EEOC received numerous inquiries about whether GINA would be violated where an employer offers inducements to employees to obtain health information about their spouses as part of a wellness plan. Prior to the proposed rule, many had questioned whether this common practice was in violation of GINA regulations that prohibit providing financial inducements in return for an employee's protected genetic information, including genetic information of family members. The proposed rule clarifies that GINA does not prohibit employers from offering limited inducements, whether in the form of rewards or penalties avoided, for an employee's covered spouse to disclose his or her personal health information as part of a wellness plan's HRA, so long as the following requirements are met by covered employers. 1. The provision of genetic information by the individual is voluntary, meaning the covered entity neither requires the individual to provide genetic information nor penalizes those who choose not to provide it. 2. The individual provides voluntary and written authorization to the employer. 3. Individually identifiable genetic information is provided only to the individual for whom the information is requested and the licensed healthcare professionals or board-certified genetic counselors involved in providing such services, and is not accessible to managers, supervisors, or others who make employment decisions, or to anyone else in the workplace. 4. Any individually identifiable genetic information provided is not disclosed to the covered entity except in aggregate terms that do not disclose the identity of specific individuals. And 5, in addition to these requirements, the EEOC is proposing to add a requirement that any health or genetic services for which an employer requests genetic information be reasonably designed to promote health or prevent disease. This last requirement was designed to make the proposed rules revisions to the GINA regulations consistent with the EEOC's proposed rules amending the ADA's wellness plan regulations. Under those ADA rules, if a medical examination or disability-related inquiry is a part of the wellness plan, the value of the plan's incentive or surcharge cannot exceed 30% of the cost of employee-only coverage. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.